Okay, everyone, so now let's talk about the core foundational guarantees of special education. And yes, I am driving. I'm in the passenger seat. A car just drove by, but everything is safe. My wife is an excellent driver, so I can focus on this video. All right. So, FAPE, IEP, and LRE. All right, three critical core acronyms in special education that you just simply have to know. All right, so let's dive into these and get a good legal grounding in each of them. All right, so first, FAPE, free appropriate public education. This is the core guarantee for every student with a disability in the United States. It makes the United States a pretty unique country. Not all countries in the world today have this type of a guarantee for special needs kids. And so it really is a thing that our kids get in this country that's a real benefit that not everyone sees. All right, super. So what is this thing? Remember, this is the first part of that basic guarantee. If you remember nothing else from special education law, the basic guarantee is what you need to remember for your special needs kids in your school. All right, FAPE as defined by the IEP for all kids 3 to 21 in the LRE. Say that to yourself over and over. Get it in your brains, deep in your brains. You'll need it. All right, super. So what is FAPE? Here is the actual definition from the federal statute where it lays out what FAPE means to a kid. That we provide an education at public expense that meets the standards of the state agency. It includes preschool, elementary, and secondary, and that it meets all of the IEP requirements later in the law. Superb. All right, so seems simple, right? A free, appropriate public education. What is so difficult about this? Well, of course, you can imagine we have heavily litigated that word free. What exactly does free mean? For instance, should a school provide a cochlear implant to a kid for free? Is that included in the meaning of the word free? Should a school provide a private school when the private school is the best place for that kid? Is that within the meaning of the word free? So we've litigated that word free quite a bit, but it does not compare at all to how much we have litigated the word appropriate. All right? Obviously, when the law says a free, appropriate public education, we're going to really have to fight out the meaning of the word appropriate in case after case after case after case. And that's exactly what we do. That is how the law works. All right, so let's jump into it. So the very first case to really try to determine what FAPE means is a case called Rowley that the Supreme Court decided in the 1980s. And in this case, it's not a huge surprise. It's actually a pretty simple case. Amy was a first grader who had a hearing disability, was deaf, and wanted a sign language interpreter provided for free to her to learn in school. All right? And remember, the law was pretty new at this point in history, and so the lower courts found that the sign language interpreter was not something within the meaning of the law. It was a huge new cost on the school, and the lower courts did not think that the school should have to bear this additional cost. All right, super. So the Supreme Court then took this decision, and you can, if you want to read everything the Supreme Court said, you can pause the video here and read the core meaning of FAPE that the Supreme Court put out. But ultimately, look at that sentence at the end. All right, they're saying the entire point of the law, the entire point of this guarantee to kids is that we must think about this not in a different way than we think about the word equal. All right, we're not going to be able to provide a fully equal education to a student with a disability that a student without a disability would have had. So whatever we mean, we're not going to mean equal. However, we are going to mean that FAPE guarantees a basic floor of opportunity. That is the Supreme Court's language. A basic floor of opportunity for every student, consisting of specialized instruction and related services that are designed to provide some educational benefit to the child. All right, some educational benefit to the child. That is where our standard currently lies. And as you make decisions as principals and teachers in the special education world, you have to be thinking, okay, what does FAPE mean in this particular instance? All right, awesome. So what the Supreme Court ultimately did in the Rowley decision was to create two core parts of the special education law. It asks two questions. First, it asks a procedural question. Has the school complied with the procedures that the law dictates? All right, and so up until the 1990s, the procedural question was sort of a small question. However, these days it's a much larger question. And then, of course, there's the second question, which is, did the IEP, is it reasonably calculated to enable the child to receive some educational benefits? If you can answer yes to both of those questions, then you have complied with the Individuals with Disabilities Education Act under FAPE, okay? That is the core guarantee. I hope that sinks in a little bit. Now let's execute it. So over time, I just want to remake this point that over time we have moved much more. We started with substantive violations. In the 1990s, we really began to focus on procedural violations. There was a move in the 2004 amendments to try to focus more on the substantive violations. However, I can't say that has had a massive impact. The procedural violations are still a really huge area of litigation for schools. Let's look at IEP. All right, so IEP is the keystone of special education. I call it that because it is the linchpin. It's what keeps this all together. The IEP is the actual process that is supposed to get the kid the core education. All right, so when it's working well, everything else in special education works pretty well. When the IEP has issues, everything else in this area is going to have issues. The IEP is the absolute critical foundational document for every single kid, okay? Gotta stay on top of these IEPs. In Kentucky, we have a meeting called the Admission and Review Committee. We call it the ARC. So in Kentucky, you got to know what an ARC meeting is. You got to know how to refer to that. The ARC meeting is simply Kentucky's version of the IEP meeting. Most other states call it an IEP meeting, but we have some leftover historical language in Kentucky, and we call it an ARC meeting. But all the same IEP meeting mandates apply. You must have a meeting within 30 days. You must meet on a yearly basis. It must be implemented as soon as the new IEP is determined in the ARC meeting. And so summer IEPs are usually the best for trying to run something for the following school year. The ARC meetings are critical principles. You've got to stay on top of these things. When you have special needs students in your building, you need to make sure that you have people that are managing the ARC situation, because if not, it's going to fall to you. All right, these ARC meetings can be small or they can be very large. Several people are involved. Of course, the parents are involved. A regular education teacher, the special education teachers, the local representative who is able to be an administrator and make administrative decisions on behalf of the school. Somebody that can understand the kids' evaluations and know what to do with those evaluations. The parents might request another specialized member to be present, any related personnel, and then the kid is invited to the ARC meeting as well. So they can be rather large. When it comes to these meetings, though, parents are the key. All right? Most of the time, school officials are generally going to be on the same page, but it really takes a lot of effort to make sure that the school and the parents align in what you hope for that kid. Okay, so you have to really make sure you're taking care of your special needs parents. There are some options for what if they can't make it, how can you schedule. Just make it work if you can. Ultimately, if parents do not come, you still have to hold the meeting and determine an IEP for each kid. All right, there's a lot on what should be in the IEP. I'm going to refer you to one of the administrative regulations over there on the side. It's a lot. Annual goals and how we're going to measure those goals, how we're going to show achievement on the part of the kid, what services are going to be provided to make sure that we can reach that achievement. Explanation when they're not in the least restrictive environment, why are they not in the least restrictive environment, what accommodations are necessary, and a much, much longer list, but that's some of the content in the IEPs. Actually, one of the best things to do is just look at the IEP forms and have a look and see what all should be in here. Okay, awesome. Now let's talk briefly about least restrictive environment. All right, here is another critical mandate on the part of special education law. When we can, we need to make sure that these special needs students are in the least restrictive environment possible. That means that they're with their non-disabled peers as much as feasible for the kid and for the school. All right? So this thing gets called a lot of different things over time, mainstreaming or inclusion. There's a lot of underlying philosophy from the civil rights era that is still embedded here, that is really trying to make sure that we're not segregating these kids, that we're not labeling these kids, that there's not a stigma attached. And there's a lot of value in peer interaction that you know, we all know that. And so it helps these kids to get that peer interaction as much as possible also with their non-disabled peers. All right, so the law, of course, lays out exactly what the LRE means. And so here's the language that they use. To the maximum extent appropriate is the language that gets used. They should be educated with their non-disabled peers, and that separate classes should only occur when the nature or the severity of the disability is such that it is the only way to actually achieve the learning for the kid. Okay, super. So this gets translated into lots of different legal standards across the United States. There's a 2-part test in some circuits, a 3-part test in some circuits, a 4-part test in some circuits. We ask here in the 6th Circuit, from the Ronker case, we ask a much simpler standard, sort of a 1-part test, which is, can the benefits of segregating of the segregated setting feasibly be provided in the non-segregated setting? All right, so if you can get the same benefits in a non-segregated setting, then here in the 6th Circuit, we would demand that you keep that kid in that non-segregated setting. Okay, so that's a little bit on the least restrictive environment, the individualized education program, and the free appropriate public education. These are the core guarantees of the special education law, and as a school leader, the things that you need to make sure each of your kids with the disability is being provided in your school. Thanks for watching.